this, we don't know what the source of the threats are. But that there are threats, on the face of it, appear to be clear. They're attached to his application. So we're not dismissive of that, and my submissions to the Commission shouldn't be misunderstood as being a dismissive of the concerns raised by Mr. Carrim. But the reality is that the relief that Mr. Carrim seeks is not going to assist him. The reality is that Mr. Carrim is known to the public. His application in the High Court to delay his appearance before this Commission was widely broadcast. He then appeared before this Commission in order to secure a postponement by agreement. Those proceedings were widely broadcast. In those open proceedings, the Commission issued a ruling that Mr. Carrim is to be present on the 9th and 10th of March for the purposes of leading his evidence, providing his version that he wishes to place before the Commission, and to be questioned in relation to his evidence, particularly on allegations that have been made by other witnesses that have come to the Commission. Now, and let me say this, in the answering affidavit at paragraph 5.1, it sets out a sample of national media coverage in which Mr. Carrim's name and pictures are displayed. And that's in relation to the High Court application. In paragraph 5.2 of the answering affidavit, there are examples of widespread coverage that Mr. Carrim will be testifying on 9 and 10 March, and those examples include visual images of Mr. Carrim's face. So there is no secrecy at all that it will be Mr. Carrim who will be testifying.
Subject to cogent explanations being given, I find some of the language gratuitous and at times both gratuitous and sensationalist. Let us look at paragraph 9.1 of the supplementary affidavit at page 54. There, Mr. Carrim says, I'm reading the last 4 lines, part of the 4th, paragraph 9.1, I said, yes. Open quote, it would be concerning in the extreme if it were willing, that is the Commission, to gamble with my life or my family's life to see whether the Commission's, underline this, kill rate would result in a, again underline, hat trick, close quote. I read this to mean that the Commission has killed, underline the Commission, has killed 2 people, and that Mr. Carrim will be the 3rd person it kills if the Commission does not grant his application. That is how I read what I've just quoted. Now, Mr. Premier, what evidence does Mr. Carrim have that the Commission has killed 2 people?
Chair, may I say that I hear what the Commission says, and that's not how, with all due respect, I interpret that sentence, because before Chair started reading from, it would be concerning in the extreme. The sentence from about 5 lines from the bottom starts with, the Commission has already experienced 2 such incidences. So with all due respect, when it's spoken about the Commission's, and I say 2 such incidences, taking the correction that Commissioner Khumalo has made already, I'm just reading out what's there. So how I read it is not that the Commission killed anybody, but that the Commission has experienced, in Mr. Carrim's version, subject to the correction, that 2 witnesses that came before it were killed, and that he's saying that the Commission's kill rate, in the sense of the number of witnesses that they've experienced having been killed, would result in a hat trick, and that he doesn't want to wait and see that happening. But that said, I take the admonition in the way that it is presented, and all I can do is apologize to the Commission if that indeed caused the offences both being gratuitous and sensationalist.
Thank you for...
That around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
But Mr. Carrim can't make his own rules.
No.
There was, from where the Commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is
that.
actually totally unacceptable, Mr. Premier.
With all due respect,
Mr. Carrim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD is not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the Commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
that your client is going to appear before the Commission is with a court application. That's the simple point I'm making.
yes,
That's the simple point I'm making. As a matter of fact,
yes.
yes. That's all I wanted to accept.
I can give that fact because
Okay.
those are the facts. I can give
Okay.
the answer. What I'm trying to resist is the path we seem to be going down regarding the timing of the threat vis-a-vis the appearance here in front of the Commission and the absence of a threat vis-a-vis the application and the inference to be drawn
No,
potentially.
I'm not at inference stage
Well, then
yet.
I have no concern.
I'm not there yet.
Then I have no concern.
I'm at fact establishing stage.
Before we go there, potentially, yes.
Potentially. So we've established page 14 does not make any reference whatsoever. So,
Yes.
this threat could, on this page alone, the source, the reason for the threat could be anything. Could be his membership of the ANC,
Yes.
could be his business associations, in any of that,
Yes.
maybe even the Commission.
Yes.
But we have no basis
No,
on
but-
page 14 to link it to the Commission.
Yes, and well, no explicit basis to do so, but...
No basis at all. What I'm suggesting is there's no basis at all.
No, that's where I need to resist that conclusion with all due respect, because
Yes.
by the same token that you put up two other possible explanations,
Yes.
his membership of the ANC and or his business interest, why is the Commission and the timing of the Commission seemingly discarded, but
No,
two
I've
alternatives
included the Commission. I've said to you, it may be the
okay.
Commission.
Well, then-
but I have no basis
Yeah.
to say it's one or the other. There are three possible bases from what I've put to you, I've proposed to you. There are three possible bases.
or more. We
for
don't know.
Absolutely.
Then we're ad idem. Thank you.
And then A2, we've agreed it says nothing about, it doesn't help anything, right?
That was the
Because-
attempted assassination.
Yeah, no, this is the death, in fact, of witness D, him being shot.
The one at page 15.
15, yes.
Yes, the apparent hit. Sorry.
Okay, so this has nothing to do with being a reason, providing a reason for your client to fear appearing before us.
Well, you've heard me on that already, and I've tried to read that in context for you, having regard to the other paragraphs in the affidavit where he gives an explanation regarding how he sees these things happening, which animate his fears. So, factually, I accept your correction of the record like I did earlier with Commissioner Khumalo,
Yes.
but with all due respect, I don't think that detracts from the underlying point, which is that even if he's misunderstood the correct facts regarding what happened in respect of this witness, that is nonetheless something that animates the fear, which triggers the in-camera. At that takes us to a reasonableness assessment. But
Yes.
so I think
of
we're
course
at Edem.
it's up to us to look at these that is referring to finally determine whether that fear is reasonable or not.
Yes.
So it's not for him to say
Yes.
of this, then we must make a decision that favors him. We have to assess the reasonableness of his fear, and we can only assess it on the basis of what he's written on. Right?
Yes,
For
I
the
accept that.
96. Okay.
But may I just say that, and I speak subject to correction,
Yes.
but the answering affidavit doesn't make these points about what could have animated my client's fears and says, oh, well, you know, you talked about two witnesses, but actually this is the correct factual position. And so in as much as obviously the Commission needs to correct the record where there are mistakes and apply its mind to the issues as they are, the point that I would make is that the Commission fails to correct that animation regarding the fear.
Yeah,
So-
but what are you saying? Okay, now that you're saying this, what are you saying we should do with that? Just because the Commission doesn't deal with it in the way that you say they haven't, are you
Yeah.
saying it's not within our powers to determine on the basis of what he has placed before us? Because maybe let me suggest this to you. As I see it, is even if they had chosen, the evidence leaders had chosen not to answer, we still have to determine your application on the basis of the case you made.
Absolutely.
Yes.
But
so it's irrelevant. It must be relevant for purpose of my engagement with you. It's relevant for purpose of you replying to Ms. Hassim, but for purpose of my engagement with you, it's irrelevant that they didn't say what you're raising now. What's relevant is your answer to what I'm raising with you.
Yes, and may I just say that I have no difficulty regarding the proposition you put to me regarding what you need to do. Absolutely, I'm not disagreeing with that. All I'm highlighting is that even his mistaken approach regarding what animates his fear is not rebutted by the Commission as a mistaken basis to animate the fear.
Okay.
So,
Mr. Premier, we have a few times said the evidence leaders are wrong in what they have said. So it doesn't take the matter any further for you to say, well, they are not saying it. As I say, you'll reply to her if she tries to make that point.
But I'm sorry, I think we're speaking slightly past each other, Commissioner,
Yes.
with all due respect. I'm not taking a pleading point in the sense that, oh, the answering affidavit doesn't put up a rebutting version, therefore on Plascon Evans. As the Chair rightfully said, there are rules that apply in a court proceeding which do not apply in these proceedings.
Yes.
All I am saying, insofar as your assessment of reasonableness is concerned and what animates the fear, is that even if he was mistaken at the outset when the application was launched, the Commission, who is in possession of the true facts and the full facts in a way that we are not necessarily in possession of, could have said under oath, here's some facts that you need to think about regarding animating your fear. And I'm not making the pleading point. What I'm saying is that I have reasonably or not reasonably adjusted my client's position regarding the in-camera. And so all I'm saying is that where the Commission itself doesn't put up a version